In today's proceedings, Nnamdi Kanu continues to defend himself against the charges brought by the federal government of Nigeria bordering on terrorism and membership of IPOB. Today is unique because today he interrogated the court and the prosecution and charged them to prove to him or to show him what law he is alleged to have contravened. You know, this is Nigeria. We practice what we call written laws. If the laws are not made or written by the National Assembly, then they are not in existence. And if the laws have been repealed, of course, repealing means cancel. If a law is repealed, it means that law is no longer existing. Now, if a law has been repealed, according to Nnamdi Kanu, he cannot be asked to stand trial on those laws. And he has asked them to show him the law under which he is tried. And it is for the court and the prosecution to say, you are tried under section so and so of this law. And if you do that, you will now check whether those laws are still existent in Nigeria. If they are not existent in Nigeria, then it means the young man may actually be correct to say that there is no charge against him. Of course, knowing that there is no law existing such as the ones we are furnished with. Part of the challenge we have in this court is that the Supreme Court had also ruled that there is nothing like Chapter 45 of Criminal Code. There is nothing like Chapter 45 of covering on Criminal Code. And Nnamdi Kanu is being tried under that Chapter 45 that the Supreme Court has said does not exist. So which law, which defense do you want him to put in a case where there is no written law? I, for one, I don't know how to even defend or interpret such. If the law is not existing, the best thing is to strike out the charge and let the young man go home. And that is why he told them, how can you detain me for over 3-4 years when the law is not existing? When the law has been repealed, when the law has been cancelled? How can you detain me for 3-4 years when there is no law like Chapter 45 of the Criminal Code? So he is challenging the judiciary, he is challenging the Nigerian authorities, he is challenging all well-meaning and all well-thinking Nigerians to find out, to ask, to raise the issue and find out whether in this country the laws have changed to such that you cannot try people when there is no law in place. Can you try people when there is no written law? If you ask me to enter a defense, is it not for me to defend a written law that I may have breached? If you say I breached section 2 million and there is nothing like section 2 million anywhere in this world, for goodness sake, are you not jeopardizing my right to fair hearing when you ask me to defend myself against section 2 million when section 2 million does not exist? That is the simple question Nnamdi Kanu posed today. And unfortunately or incidentally, the court ruled that it will not answer that question now, but will answer it at the end of trial. And Nnamdi Kanu is saying, how can you try me when there is no law? You must first of all cross the hurdle by bringing up the law that I preach. Then you cannot try me under those laws. If you cannot try me, if you want to try me under a law that does not exist, then it is a breach of my fundamental human rights. So that is as simple as Nnamdi Kanu put it today in black and white. And he relies heavily on section 35 or 36, subsection 12 of our Constitution. Thank you.
Well, anyway, I'll just say a few words. There is this saying amongst lawyers generally that a goat was running, and when the dog saw the goat, the dog also started running. Well, the fowl observed what was going on and asked the dog, "Why are you running? It is the goat that they are chasing." The dog said to the fowl, in this country, Nigeria, if they are chasing a goat and you are a dog, you don't run, if they catch you as a dog, before you prove that you are not a goat, you will take 10 years to 20 years. This appears to be what is happening to our brother Nnamdi Kanu. I don't speak as of counsel, I speak as of his brother, as a fellow Igbo man and as a Nigerian, to strongly condemn what is going on. This has been going on since October 2015. You have a man on trial since October 2015. That's over 10 years ago. And out of these 10 years, you detained him for almost 6 years. And you still have him on trial. What does that tell you? It tells you the story of the dog and the goat. It's taking him 10 years to prove what, or to disprove what, or 10 years for the judiciary of Nigeria to find him guilty of what? Guilty of self-determination, guilty of making a broadcast from Kenya or from UK. What are we here for? What are we talking about? Why are we distancing ourselves? Why are Igbos keeping silent? I'm calling on Igbo leaders to speak up. What are you afraid of? Second term or what? Go to President Tinubu and tell him, Mr. President, what you are doing to our brother is wrong. Stop it. You have stopped it in other instances, in other cases. You stop the prosecution of Iwo. You stop the prosecution of Showore. You stop the prosecution of the secretary or chairman of Mietiala. Why are you pushing ahead with the prosecution of Nnamdi Kanu? Simply because he's Igbo? Why are you doing that? You should stop it. They have the power. Well, the blame, you can lay some blame on the judiciary, but in this very case, the buck stops at the president's table. The blame must be laid where it should be laid. The court cannot activate any trial without prosecution. This prosecution has hit a gridlock. You should stop. And if they have issues with Nnamdi Kanu, they should call him to the table and settle those issues. And the issues are clear anyway. It's self-determination, that is all. Every other thing that is coming under that is trumped up, just to make it look like a case that is fit to be settled by the Nigerian judiciary. I'm here to tell you that it is not possible. It is not possible. It has become very, very clear. If anybody keeps insisting, the courts must settle it. Think of the person that stole your election, and the moment you open your mouth, he says go to court. Why are we insisting on the courts settling this matter? Is somebody contriving something in the courts? The politicians can settle it as well. Political leaders can settle this, and the number one that should settle this is Tinubu. He should not inherit Buhari's hatred of the Igbo. He shouldn't do it. He should abhor it and make his new friends or make his own enemies. But by all means, he should not inherit an enmity brought by Buhari in 2015 against the Igbo, of which Nnamdi Kanu is the poster boy. Thank you.
For the Igbo Union, so taking it up from there, you see, the war is on Nigeria now, based on the American President Trump's threats. And if you watch in the court today, we have about 2 or 3 foreigners covering this event. I want to plead with Mr. President, please, this particular trial is embarrassing Nigeria. Tell me the law upon which you are trying me. Tell me the law upon which I violated. Now, he has filed a motion, and to clear this particular doubt, Nnamdi Kanu is not running away from defense. Remember that he has already filed his witnesses, about how many of them? 23 of them, to tell you that he was ready to enter into defense. But in law, if you see something that you're supposed to raise and you do not raise it, it may be seen as you waving it. And based on that, thank God that of course you will know that he's intelligent, you will know that he's a good insider. So based on the advice by his consultants, both foreign and local, and his own research, he discovered that there was no even law, just like my colleague said. So he said, what am I entering to defense for? So that gave rise to the motion he filed. And in that motion, he raised a lot of issues. Now, my lord said, please, you people talk about extraordinary rendition. And I want somebody to come and testify and give evidence towards that. And Nnamdi Kanu said, no, you cannot need any other evidence. Where the law has mandated you to take judicial notice of every law, every judgment, every document in the court file. In that judgment in the court file, there is Court of Appeal judgment there. There is a Supreme Court judgment there. Right. There is a Federal High Court judgment there. There is Kenya Court judgment there. United Nations. All these judgments are in that court file. And the court is expected to take judicial notice of all those issues. And the Master can also file notice of preliminary objection. In that notice of preliminary objection, he also raised all these issues. And that was why Master Kanu said, my lord, during your during your no case submission, ruling on no case submission, you failed to take judicial notice of all these issues. So I believe that without going into what is pending in court, I believe that my lord will reconsider this particular motion, because my lord said that I have seen the motion. When the prosecution said that the one he had was not stamped, my lord said no, the one in the court was filed, was signed, and the court belief cannot serve you on stamp and unsigned document. I don't know where they got that one, but whatever that is the case, court has confirmed that it's in the court file. I believe that my lord would have, nobody is above mistake, of course. In fact, court is not a court of know-it-all. Court is expected to raise issue where you are confused or something that you need to clarification. You ask, please, can you address me on this issue? I expected my lord to say, these things this guy is raising, can you people address me on it? Let us pass the hurdle. You can make your judgment in one way or the other. You are in one way or the other. I don't say so. Master Nanka said, I cannot. The Lord did not say I should enter defense. The Lord said that you should do this. So that is where we are, and I believe that just like Special Counsel said, the Igbos, Nigerians of good conscience, you people should rise. Like when the issue of June 12 came up, all of us in this country stood against it and work against Abacha. Without finding that Abiola is involved, Abiola is not involved. We collectively fought against that. Why should that of Nnamdi Kanu, everybody is running away? Probably because of one or two contracts you are getting, because of the mantle the president calling good person. The president is just like Buhari today. Buhari died in this country, and everybody was jubilating, including people of Daura. They were jubilating that Buhari died because of the bad legacy he left for himself and for his children. Mr. President, you are a Democrat, you fight for this democracy. Please, you know that Nnamdi Kanu never committed anything. They arrested him so as to stop him from agitating. Please, release him and allow him to continue with that agitation and dialogue. Thank you.
The law that I have contravened. Yes. You cannot ask me to enter a defense for a law that does not exist, and particularly the law that the Supreme Court itself has declared non-existent. So what will I be defending? We're in a country where our laws are written. This is not England where you have an unwritten constitution or unwritten law. We have a country where all our laws are in black and white. This is a lawmaker here. They made the law we're talking about. And if you ask him, he will tell you that there is nowhere they made chapter 45 of the criminal code. They didn't make it. But honorable, people make that law. It is not in existence. So who made that law? Who made that law? Was that law made by the Attorney General's office? And the Attorney General does not have the powers to make laws. So I am saying, as an ordinary citizen, that Nnamdi Kanu is completely right and within section 36 of the Constitution, which borders on his fundamental right to fair hearing, to be charged with in a court with a law that is in existence, not with a law that is not existent. Thank you.
I'm facing corruption charges. They sent her to my case so they can release. There is a breach of judicial oath. They have violated the judicial oath. They have shown bias according to Supreme Court. They are biased against me. Supreme Court said so. And that is why what is happening in the judgments and rulings concerning me has been happening. Disobedience to Superior Court orders. Supreme Court said you are biased.
I want to let the whole world understand something very, very clear. In all this is judgment of the Supreme Court. It made it very clear that even that the impartiality of the judge is questionable. And is here. Please do bear with me. It says it here. I like what is it. Page? What is that again? Where
it's even online.
Where it says page 18. All these things are online. Yeah. Is it on page 18? All these things are online. So I suggest that the journalists in this country actually take out time to do some basic research. It's not difficult. Just minor research. You will understand the vacuousness, the emptiness of all the charges against me.
Page 18.
Okay. They kept switching the charges.
Yes.
They said I committed this crime in England, isn't it?
Yes.
I made a broadcast in England.
Yes.
And in 9 charges leveled against me, the place where I committed this crime was London, United Kingdom.
Yes.
When my lawyers came to see me,
To discuss his
I had a discussion with them about how I'm going to defend myself.
They removed it.
I told them that no court in Nigeria has jurisdiction to try me.
They removed that long.
Because since this offense was committed in England, so they said, it's only a UK court that can give a Nigerian court the authority to proceed, isn't it?
Yeah, based on that, they removed London.
Based on that, they now amended the charge again and removed London.
Location of the broadcast.
Location of the broadcast. Contrary to section 196.
174 of the Terrorism Prevention Act 2022.
In violation of their own laws. Violation of their own laws. And you want me to stand trial under such circumstances? Is that possible? Nnamdi Kanu to stand trial where all these shenanigans are going on? It's not possible. In this court, I'll defeat the government of Nigeria. Here, the whole world will see it. Where is the treasonable felon? Where is it? All these years, journalists are having treasonable treason. What is treason today? It's gone. In some way, this terrorism charge will go. I'm thinking of another capital offense that can charge me. Maybe, I don't know, impregnating the wife of somebody. I don't know what other thing they're going to charge.
Are you saying you are innocent of all these charges?
The federal government, they know I'm not guilty. My only guilt is that I'm fighting for my people, and I will fight for them for justice and fairness and equity everywhere. Our family is based on 4 cardinal points. You must be without fear before your enemies. You must speak the truth always, even if it leads to your death. You must help the poor and those who cannot help themselves, and be of good character that God may love thee. That's who we are.
You're taking this. How are you? Good to see you. How are you doing? It is well. It is well. Bless you, brother. Bless you. Thank you very much.
Anybody standing in trial or coming to try me is a terrorist. That's what their law says. Section what me?
As simple as that.
Section 2, subsection 3F of Terrorism Prevention and Prohibition Act. That's what it says. Any court considered to try me is committed an act of terrorism.
Yes.
Very clear. You cannot violate a treaty that Nigeria entered into and then come to try that very person. Is not done anywhere in the world. So you must be aware of that. So that is why there is all these ridiculous delays. That is what Supreme Court said. I did not jump bail. My home was invaded. They came to kill me and I survived. They came to Kenya to kidnap me, brought me back to this country and seeking to try me, which the law says cannot happen. You cannot violate a treaty that Nigeria entered into and then hope to stand on that illegality to conduct a trial. Is not done anywhere in the world. Where's the lying news agency of Nigeria? Are they here? Those liars and deceivers, are they here? That distort the news. You don't know what law is. You don't know what justice is. Where's the news agency of Nigeria? What are they? You don't know that God is a God of justice. You don't know that? That God in heaven is a God of justice. You don't know that? But that's what you wrote. You said here, my lord, that the defendant has now applied for bail. Now, as I've said earlier, there is a decision of the court taking into consideration all the conditions laid down in Muhammad Abacha v. State. At this stage, I am of the opinion that to make or take a stand on the bail application without first hearing and determining the issue that is glaring in the face, which is the absence of the defendant from the court since 25th of April 2017 until he was produced on the 29th of June, my lord, which was exactly what the Supreme Court did. They said that he did not jump bail. These criminals came to my house to kill me. That's what the Supreme Court said. This is in your own court, my lord. So I cannot understand, my lord, why my trial will be conducted contrary to the Constitution of Nigeria that said I must have free and unfettered access to my counsel. Is here. Okay. He did something in my case. I refused him. He was conscious of issue. I asked him to recuse himself. Why did the chief judge insist I must hear it? He left my case.
Okay, listen. If anybody is not happy with this, then you need to go and
no, I cannot. Because I have a court order. I have a court order. You have refused yourself. I have a court order. Anybody who disagrees with this order of court, go to appeal court. That's what you tell me all the time. You are from this official. You cannot preside over this case number again. Not in this life. You cannot. Not now, not tomorrow, not ever. A woman here cannot force this court to preside on my case. You cannot. Not today, not till forever. You are recused and you stand recused. Tell the chief judge, Nnamdi Kanu said, go on appeal. I recused him from my case. The state recused Justice Adema from my case. I did not insist Adema must hear my case. I never insisted. So why must you insist to hear my case? I don't want you in my case. I don't need you in my case. You are biased. You are biased. You cannot be in my case. A woman should do the right thing. A chairman of the board of managers prosecution is impropriety. Nowhere in the world such nonsense done. You cannot be hobnobbing with lawyers, hobnobbing with justices, and you're proceeding a case. It's shameful. Absolutely shameful. Shameful. This is a court of law. This is a shrine to injustice. And I will not subject myself to it. You stand recused and you must take my case. You cannot write me. This man is not paying attention. There is an order of recusal. And he's a senior advocate, for goodness sake. There's an order of recusal. Is that not the rule of law? The law says if you disagree with this, you go on appeal. You are a grown-up man. Because of 300 million, you're behaving like a child. Go on appeal. Because of money. Because of money they're paying you from ATM surface, you are here standing and smoking evil. Because of money. A grown-up man like you. You say you have to behave like a man of honor. The rule of law says you go on appeal. His Lordship Peter, you will not try my case. Not on this planet Earth, I'm telling you that now. So stop wasting your time.
So that, as I said, the view of the past that the defendant has indicated that he will not make a formal application. I apply that the Lordship was a 70-day for hearing.
You are not well. You are not well. I'm telling you, this is what I'm not well. This is an order of court. An order of court says Justice Binta Nyako is recused. An order of court. Order she made as an order. The same Chief Justice writing the stupid memo he's writing. I recused him. He was functus official. He sat on appeal. I took him to the NJC. I recused him. Why did he not say I must sit on your case? Why in the case of his lordship is he insisting? He wants to embarrass her. He wants to embarrass your lordship by asking her to come and sit on this case. Is that what you're saying? There's an order. Give it to him. He doesn't have it. Give him an order of court. It's an order of court. Give it to him. He doesn't have it. Give it. He doesn't have it. It's an order of court.
I take your permission.
It's an order of court.
I take your permission to address you. But let me tell the defendant that in everything life, there's need for wisdom. And wisdom is very important in this matter.
And telling lies.
It is not right for you to be insulting the teacher.
If you insult yourself, I will insult you. If you have no respect for yourself, I will insult you. Because people are telling the law, when it comes to Nnamdi Kanu, you turn the law upside down. The law says one thing. If the law says this paper is white, when I go to court, they say it's black. When I say it's black, they say it's white. Is that law? I'm asking you, a senior advocate of Nigeria, is that law? Is the memo from Chief Judge, is memo from Chief Judge sufficient to set aside and a court order? The answer is no. Why do you want to change the law in my own case? His Lordship, Justice Netanyahu, stand recused in my case. Cannot try me. Why don't you get it? You mean you definitely get for trial so you can do your mathematics you always do. To go without shame. I have here before me for the benefit of Chief Awomolo because it seems he doesn't know the law. So I will tell him, this is national judicial policy of this country. Please give them a copy each. National judicial policy of Nigeria, national judicial policy. I will tell you what it says. Because you don't know, I'll tell you. Talking about memo from the Chief Judge of the High Court. Judicial policy of Nigeria, 1C, I'm reading, verbatim. In the performance of judicial functions, the judge is subject only to the law and must only consider the law. The rule of law in every common law jurisdiction in the world is that once an order of court is entered, the only way to set it aside is by going on appeal. That's the rule of law. But the senior advocate, you don't know. I will go to see. A judge must not take or attempt to take orders or instructions of any kind from anyone, even the chief judge, from anybody that may influence his decisions in the performance of judicial function. It means that his lordship, having entered an order of court, a decision between myself and her.
We are seeing a surprise development. Remember that Omoyele Sowore led a protest hashtag free Nnamdi Kanu now, where he shut down Abuja for Nnamdi Kanu. But surprisingly, Sowore appeared in court today, and we have seen that he has been arrested. And Sowore is someone who has visited Aloji Meko the other day, and he submitted a bail application. What are we seeing? What is this new tweet?
I think a total clampdown on resistance voices and voice of freedom. It becomes very relevant as a result of Nnamdi Kanu on this issue. And before now, I can tell you there was a court injunction stating that Sowore should not be allowed within the court premises, you know, and that statement was issued by the court, and Sowore, which for now does not hold any water. Sowore actually went to court because Nnamdi Kanu is appearing in the court today. We don't know whether actually it was based on that he was arrested, or based on the already the development that we are seeing at this moment, where Nnamdi Kanu has finally taken a decision to actually open defense. And but if you look at Omoyele Sowore's arrest, you know, he sent another strong signal that Nigerian government has actually declared war on justice, has actually declared war on freedom. Sowore's arrest, as I report to you, right there in the court where Nnamdi Kanu was seen, you know, attending to his court appearance today.
You can clearly see Sowore and of course Nnamdi Kanu while they were moving together, even right in the arsenal. Viewers can see the picture on the screen.
Yes, they can watch the video of how Sowore was actually, you know, arrested, you know, and taken to unknown location. But let me tell you very clearly, you know, that issue of Sowore's arrest is going to trigger another form of, you know, discussion centering on how this government have become tyrannical and draconian to
let me even ask this. Is it because Sowore had hinted the other day that he's going to give updates as to the next line of action
sequel to another protest. Yeah, maybe because they don't want another protest. It's not necessarily if Sowore does not lead any protest. There are thousands of them here who can actually lead the protest and still make impact. I can tell you that. Outside that, a day has not been fixed for another, powerful, impactful protest in that regard. As in Freeman's Nnamdi Kanu now protest, and that's already, getting international acknowledgement. Let me put it that way. International attention. And the Nnamdi Kanu factor has continued to generate, traction in all ramifications. So if you look at what actually Bola Ahmed Tinubu want to achieve with all this, he's really painting his government in really, bad light. Considering this latest development where the leader of revolution now, Omoloye Sowore, has been arrested right inside the court. The arrest of Sowore will trigger another form of uprising. Let me put it that way, because Nigerians will not like to see that kind of a thing, happen. And we were seeing severally in this part of the world under Jonathan, the way a manner protest was being led in this country. It is a civil responsibility. It is a civil right. Arresting Sowore will not solve the problem. The government themselves should look inwards and see how they are going to manage this issue so that it will not turn to something they cannot handle after. These are people, these are figures the entire masses of Nigeria see as a symbol of hope, as a symbol of freedom, as a symbol of defense, as a symbol of justice, and those who cannot be able to speak for themselves, the voice of the voiceless. So it can trigger, it might have a multiplying effect, a spiritual effect on this government if care is not taken. I want to say it very clearly. That action has been taken right there in the presence of the presiding judge, James Omotosho, and I can tell you that those DSS that were involved, it happened in the presence of Omotosho, and the presiding judge was not able to stop the arrest of Sowore inside the court. It's quite unfortunate.
But is Sowore becoming a threat to the government?
Sowore is not a threat to anybody. I can never be a threat. If Sowore is a threat to them now, then what happens under Jonathan? And when Sowore was seen as part of the protest that led to, I would say it was the downfall of Jonathan, but we see how prominent figures in this country led a protest against Jonathan and said a lot of things about Jonathan. Jonathan never arrested anybody, but it tells you that a lot of things is wrong and factored into what the government does not want the Nigerian masses to know about how they are managing the instrument of justice in this country. And you see, I repeat again, I want to be quoted. Every Nigerian was born a free man, then how come we suddenly become slaves under APC?
But do you think the government can manage #free Nnamdi Kanu, #free Sowore? It's becoming too obvious that
it depends on how long. It depends on how long they want to keep Sowore in secret detention. You understand? Then that will now be another factor that will determine what is going to happen. But I think the whole thing is being modeled together. Let me just say it one thing. If some people have been listening to one of the former CIA writer, James Hadley, he said it very clearly. That too many fish in the pond will stay up the mud. What is building up currently now can stir up a revolution in Nigeria, and they will not be able to stop it. Arresting Sowore is not the solution to what is happening now. If and as much as under Jonathan we saw a lot of protests that took place, why is the Nigerian government going after people who are protesting to what they feel is passive judgment to their plight? That is not democracy anymore. What we see, this thing is becoming, tyrannical, and it's a sign of an emperor in power, and I think to an extent Nigerians can decide anytime to rise against this clamp down on resistant voices in Nigeria. Like the likes of Sowore. Sowore and Nnamdi Kanu are not in the same line of agitation. But I can tell you, I remember some time ago when Sowore was also apprehended. You can take you back during the days of Ezazaki, when both of them were in custody. Nnamdi Kanu was in London, and he uses his platform to advocate for the immediate release of Sowore and Ezazaki.
So what Sowore is doing like a payback time?
I wouldn't say it's a payback time. What has triggered Sowore's leading a protest is circumstantial, because Nnamdi Kanu has attracted sympathy. Nnamdi Kanu has attracted international attention. Nnamdi Kanu is being seen that what is happening to Nnamdi Kanu is a deliberate act of injustice, and that was what triggers the likes of Sowore to step in and start calling for Nnamdi Kanu's release. And the law does not justify that Nnamdi Kanu actually committed an offense. That is the first thing you must understand.
No, the law presumes him innocent or the proven otherwise.
No, it's not a matter of, we don't want to go there. There's no presumption here. It's a matter of presumption. What the law has stated should be respected. In October 2022, the appeal court declared the child unacquitted. The matter was taken to Supreme Court. So then you all came back and ordered for the trial. So what is the justification? Apart from that, you do not continue a trial in a court of competent jurisdiction in a situation where a criminal act was being perceived to have been conducted against the suspect. It is no longer the law. Nnamdi Kanu is in DSS custody because of interest.
Let us briefly look at Nnamdi Kanu deciding to sack his lawyers and is calling some big names as witness to his case. The names like Babaji Sanwo, of course.
Nnamdi Kanu did not. Let us put that record very correct straight here on this point. Nnamdi Kanu never sacked any lawyer. Nnamdi Kanu opened defense because the presiding judge, James Motosho, said that Nnamdi Kanu has a case to answer. Yes, then of course the federal government have closed their defense. That is okay. He submitted no case submission. He came back and said he has a case. This is the case now.
What do you make of the big names are hearing?
He is going to defend himself. He's going to expose them to the law. Yes, let them come and prove. Let me tell you why he mentioned Sowore. Nnamdi Kanu, one of the charges against Nnamdi Kanu, where they are using against him, was the issue of answers. And if you look at what the Lagos State government, the panel they said on answers, nobody mentioned Nnamdi Kanu's name there. So Sowore should come out and defend how Nnamdi Kanu ignited the answers thing. As simple as that. With the panel report. So the whole world will see where Nnamdi Kanu's name that appeared in that panel. So it's a case of suicide mission, live or die, whichever way Nnamdi Kanu has turned the table against them. And that is where they are seeing Sowore, that they need to keep in one side so that nobody will begin to trigger what they saw happen in October 20th. But unfortunately for them, we have thousands of resilient activists currently now tied to the freedom of Nnamdi Kanu from all over the world.
Thank you very much for your time. It's a development story. We hope to have you on this later, but for now, I must say very big thank you for your time.